you, Mr. Nell.
May it please the court, milady. We lost one question only.
Oh, okay.
Two
questions.
Two questions. The one is where I put to Dr. Fairfeld, if the accused can see, if there's light, the risk of falling is less.
Okay. All right. Doctor, you still under oath? You are still under oath?
Yes.
Yes, thank you very much.
Yes. If there's light, the risk is less.
Then I asked you, just before we stopped, why did you say that the accused will be severely impaired, the accused has a severely impaired ability to ward off danger without a weapon? And the question is, why did you mention without a weapon?
Because, in fact, this is a trial about using a weapon.
So, in fact, what we have then to take into account is you try to ensure that your report is relevant to the trial.
I did try to make it relevant to the trial. The question of a weapon, if you make that statement under the circumstances, I didn't think it made sense. If you made the statement without putting in the weapon, then I didn't think it made sense.
So would the flip side be true that if he had a weapon, his ability to ward off danger would not have been severely impaired?
He is still impaired, but it would not have been as impaired as if he didn't have a weapon.
You see, Doctor, and unfortunately, I'll have to put scenarios to you because we're still busy with the trial and the court's made no findings of fact. Now, you would agree, having observed what you did, having made the clinical finding that you did, if it was dark, that would have affected it. It would be more probable that the kids would be unable to walk or run without holding onto something and falling. You agree to that, am I right?
Yes.
And also, if there were things in his way, like, let's use a duvet. If it's dark and it's on his prosthesis and the levels would differ, that would also cause a fall.
That would also be a problem, yes.
And things like electric cords would also be a problem for the accused to walk over.
If he stood on an electric cord, that would be a problem.
The information you put in your report in the first couple of pages, let me just say that's from page 2 to page 7, line 1, those you got from the accused?
Yes.
In what format? Did he come there with a document?
No.
You asked questions?
I asked him, what is he like on his stumps? And I asked individual questions, yes.
And in asking these questions, you had the trial in mind?
In asking the questions, I had in mind to try and establish the disability that he had. on his stumps. And obviously that information was for the court, yes.
For the court.
Yes.
The last issue I just want to canvass with you, Doctor, is based on your interview and your clinical understanding, it would be unlikely, highly unlikely, that the accused would be able to walk in an area where there are extender cords, fans standing, duvets, an iPod, a head shaver in the pitch of night and not fall over or bump against it.
If it was indeed pitch dark, that is so.
Good. Thank you, my lady. I have nothing further.
Thank you very much. Yes, Mr. Roux?
Thank you, my lady. Doctor, can I move closer to the context of the case? You were asked a number of questions, and I'm going to do this now with page references to assist the court. And the one is that the evidence was there was a slight illumination so that he could see the jeans, the denims. My lady, for the court's benefit, it would be pages 1734 and 1807. So it's not that it's pitch dark to stumble over.
It's 1734.
I'm sorry, my lady, 1734, and also relevant to that's page 1807.
Thank you.
So it's not that it's pitch dark and it would stumble over the jeans, the denims.
Well, the moment there is light available, he will be able to use his vision to balance, to help him balance.
The second part that I try to stick to chronology is, on his evidence was that he went to the side of his bed to fetch his gun, and he explained that he was doing so by touching with his one hand on the floor for balance purposes. Would that make sense to you? That is page 1471, my lady.
Yes, my lady. That would make sense.
Would that be consistent with your findings?
Yes, my lady.
Now, we're not talking about Mr. Pistorius running around the track. We're talking about short distances. From the bed to the entrance of the passage is about 2 to 3 meters. And there was light coming from the bathroom, so there was some illumination in the passage. And he's focusing now on the passage in moving there, my lady. That would be pages 1774 and 1832. Now, you were talking about a focal point or some sort of visual reference.
Yes.
So what I'm putting to you, it's not that he's walking in the dark. He's got a focal point. He can see light ahead of him in the passage.
Yes, my lady, not only that, but if he's walking in a passage, my observations were that he would have been touching the walls as he goes along, because he's not sure on his feet. So there would have been some form of touch as well as the light, if it is something that he can touch onto.
Well, I'm getting to it. The first point that I make, the path from the bed to the passage, that's about 2 to 3 meters only. And there is a vision point, a focal point. But now I'm going to the passage. It's about, the width is about 1 meter, maybe a little bit more. But this was in fact this evidence that he used his hand to balance himself against the cupboards. That would be page 1837, my lady, and 1771. Would that make sense to you?
Yes, my
So
lady.
it's not this man walking in the dark, in the pitch dark. It's also not an outstretched hand as demonstrated to you. The firearm was in front of him and the elbow close to the body. Would that make sense? And the other hand was, of course, then finding some assistance against the cupboards.
Yes, that would make more sense than an outstretched hand, my lady.
And lady, just, if you will allow me, I'll give you the page reference for the elbow. It's 1831, my lady.
Thank you.
And we've dealt now with leaning, the shots came about, I'm not going back to that. He moved backwards, and again his evidence was balancing with his one hand against the cupboard. Would that make sense?
Yes, my lady.
Now going into the bedroom, that's dark, but we talk about a distance of 2 to 3 meters of a person knowing where his bed is. What would that do? Would you want him to fall? Would you think he would fall?
Well, if he knows where the objects are, that would help protect him from falling. Yes.
And we've dealt with the fans, and I'm not going to deal with the evidence holding on to the bed and so on. What I need to know is this. And in all fairness, maybe a difficult with Mr. Nell's questions, I saw when you demonstrated that he was not looking at the legs at all, what you demonstrated. So I sort of understand it, but if you look at the pain factor, what is it if you're in that state of mind? Is it something like adrenaline or any other substance that the body would excrete? And what would that do, if at all?
We all know, my lady, that if you are in a dangerous situation, or in a situation where you are fearing, that allows you to do maybe a little bit more than you normally can. That is so.
Then it was put to you, well, if there's an iPod and a head shaver and a number of objects that you would expect him to trip over it or fall over it. That's, of course, if he came in contact with them.
Absolutely.
Would he necessarily fall when he walks over the duvet? Right next to the bed?
If he put the foot down on a thing that he wasn't expecting, he would be in danger of falling.
Yeah, I understand danger of falling, but would he fall as a fact?
No, not necessarily.
Yes. And would it make a difference if the bed's right next to him?
My lady, if you watch him walking, he is looking for places to put his hands so that he can balance himself. So if he knows that he's got an object nearby, that would allow him a little bit more freedom, because then he could either touch and balance on that, or if he fell on that, that wouldn't be the same as crashing onto the floor.
Now, you said right at the beginning of cross-examination, when reference was made to Mr. Pistorius' version of running, have you asked him to demonstrate to you over the time what he would consider as running?
I haven't witnessed Mr. Pistorius running. I've witnessed him walking.
On the stumps, what would you say? What could that running be? You said it's not running as Mr. Nell would.
No, I mean, it would be a number of very short steps, and it would be quite cumbersome. My lady, when he puts his leg down on the left side, the stump has to be in a specific position. And he actually goes down on the left side each time he takes a step, because the knee is bent and it is turned inwards, and you can actually see the leg buckling a little bit when he puts weight onto it. So it wouldn't be running as you and I know it, my lady.
Thank you, my lady. I have no further questions.
Thank you very much. Doctor, thank you very much for your assistance. You may be excused.
Thank you, my lady.
Yes, Mr. Moore?
Just seeking indulgence of only 5 minutes, my lady. The next witness available, I just want to get the reports ready.
We'll take a break. Yes, Mr.
My lady, before I call the next witness, there are 4 things I need to do. One will stand over, that's in relation to a photograph that Mr. Nell just needs to check whether that can go by agreement. And then there would be 3 other matters. The one would deal with the electrical cord. I'll come back to that. The second will deal with the report, the guard track report that on page 431 we said we would hand it up, but somehow it was never handed up.
What report is this again?
The guard track, you remember when Mr. Peter Baba gave evidence,
Yes.
he was asked about it where he activated.
Yes.
And I
yes.
said that it would be handed up, but somehow it was never handed up.
Yes.
But I'll come to that. And the third one is, there was also Mr. Dixon's report that was made available, and I said at the time that it should be handed up, and it was agreed. That's 2024, but it was never done. So it's just to get that in order, my lady. But the first one, my lady, is if I may make the documents available to you, that's triple S as triple S. It's a very short application, my lady, and it's just the documents to support the application. What happened, my lady, that during the adjournment, we saw that a number of questions were asked by Mr. Nell in cross-examination of the accused about the electrical cord and if it could move or not, if it could go longer or shorter. So we wanted that cord on account of information that we have. So the first document in triple S was a letter then addressed to Captain van Aert saying that, please can you make available to us for inspection as soon as possible the electrical extension cord that was removed from the main bedroom.
Yes, where are you reading?
That is the first document, my lady, on top. You will see it says Chambers, and then Dear Mike.
Oh, okay. Thank you, yes.
And then there was a response. The rest is just proof that a letter was sent. And there was then a formal letter because the response came back that the police did not have the extension. And the letter came back to say, but it cannot be, and that you will see it's a letter dated 6th of June 2014, where we refer to image 0184 at 5:58 on the 14th of February. And you will see that photo if you just page on, my lady. There's a copy just to make it convenient to the court. You will see the extension cord there.
Yes.
And we say that's there, but if you go the next day and we give the time there, we say image 0856 at 6:34 p.m. on the 15th, there's no extension cord. And we say, you had sealed the house, where is that cord? Because we need that cord. The Captain van Aert then came back and said, well, I hear what you say, and that's what the letter's saying, we don't have the cord. And we again say, but it cannot be, we need the cord, and the letter comes back, but we don't have the cord. So we say it cannot be, and we ask the court to consider ordering the state to make the cord available, because that's important in the accused case. To get the length, we say it's 5 meters long, and we need that to show that to the court, and as an answer to the cross-examination. And the difficulty, of course, is that the state tells us that they don't have it. No, they took possession of the house, so to speak, and it's not good enough, we say, to say we don't have it. Someone must then explain at least what happened to it. They secured the house, they sealed the house. Where is that cord? And that's a difficulty for us because we really feel that we're prejudiced, my lady.
Thank you. Okay. Yes, Mr. Moore?
May it please the court, my lady, with utmost respect, if I may refer to the short answers, I don't have it. The state, we don't have it. I know that Mr. Roux would refer to photographs, but, my lady, the court cannot order the state to make something available that I inform the state we never ceased in my consultation with the investigator, we never seized the court and we don't have it. So therefore we cannot make it available.
Where is the inventory? Was there no inventory?
Of seized items, yes, my lady. It's not on that inventory.
It's not on that inventory.
Of seized items, my lady, no. So, my lady, the defence now approaches the court to make an order to order the state to make it available. But it's an impossible order. Where I'm standing at the moment, my lady, the state cannot comply with such an order.
If it's not on the inventory,
Yes.
it means it was not seized by the police.
Yes, my lady.
But it was in the house.
Yes, my lady.
That is common cause.
My lady, if I look at the photographs that was indicated, yes, it was in the house on the 14th. That is true. And the defence has now indicated on a photograph on the 15th, it's not in the same position as it was on the 14th. But, my lady, it's not in the same position, my lady, because there's a photograph of the position where the court was. It's not there where it was on the 14th. That's the most anybody can say. But, my lady, where it is it moved somewhere else? Was it left in the house? Did somebody take it? I cannot answer those questions, my lady.
Well, maybe the police can.
My lady, I'm asking on their behalf. I'm answering on their behalf. They can't, my lady, because it wasn't seized by them. They will be able to say if it was seized by them.
Yeah, it's very strange.
It might be, my lady.
Because, I mean, they locked the doors every day. It was under their control.
Indeed, my lady.
And it can't walk.
My lady, that's all true. And I'm not saying that I have an explanation for it. What I'm saying, my lady, is that the position that the state is in, or that the defence is putting the court in, is to order something. Which
Well, I'm not about to order something. I can't even read this. But I'm very concerned. What could have happened to it?
Indeed, my lady. My lady, I cannot even advance.
No. But the state has to know what could have happened to it.
Well, my lady, I say
It was in the-
it was left in the house somewhere.
It was left in the house.
Yes. My lady, the court will ask me to come up with excuses and or explanations. There are lots of those, my lady. That it was moved from that point and it was left in the house when the house was handed over. In all probability, it was still in the house. Not at the same spot, because lots of things moved. Even one can see it on those photographs.
Yes, but there must be a chain. At the time the police handed it over to whoever, was it still there? Was it not there?
My lady, there wasn't a formal handover of what was in the house and what was not in the house. That did not happen. There wasn't what happened is the key was handed over to Mr. Stander, and Mr. Stander handed the key over to the defence team. The police did not make an inventory of everything they left in the house. That never happened.
Yes,
So, lady, I wish I didn't have to try and explain it. But I'm in an enviable position that I just cannot. And I don't have it.
Well, I'm not happy, but at the same time, I don't know how I could order the state to produce something that they say is lost. But how it was lost, that is my concern. How? How did it get lost?
It's a concern, my lady. And I say it with the utmost respect, I cannot blame anybody to be concerned about that. But the reality is, my lady, that I'm standing next to the investigating office. And I don't have it. Well, my lady, let me rather say, it wasn't handed in or seized, formally seized on the scene in terms of inventory and handed in into the police's exhibit facility.
But did someone look for it since the correspondence happened? Did someone try to look for it?
My lady, in terms of look for it, that would mean at the police station, an exhibit store, and those kind of things. Because
No, well, if you say everything that was seized was in the inventory, and it's not in the inventory, I wouldn't expect the police to search for it at the police station.
wouldn't, I perhaps didn't hear correctly. You would expect the police to go search for it.
I wouldn't expect them to search for it at the police station,
Yeah.
since according to the inventory, they didn't take it.
Yes. So,
But since the request was made by the defense, did someone try to find it?
well, what happened, my lady, is that at page in the document that the court has,
I can't read most of it. It's just impossible.
yes, my lady, second page I cannot read, lady, but maybe count the pages. Page 1, 2, 3, 4 is a photograph, my lady.
Yes.
5 is a photograph. Then on the next page, my lady, there's a response by the investigating officer at the bottom of the page where it's indicated by Captain van Aert. I again checked all relevant entries pertaining to exhibit seized. I also consulted with Warrant Officer van Staden about the seizure of exhibit. The extension cord is not in the possession of the SABC, nor was it seized from the scene. And that was, the defense was informed of that on the 9th of June.
That means no one tried to look for it because the police did not seize it.
Well, my lady, to try and look for it, I say with the utmost respect, my lady, we looked for it in our records. Mm-hmm. We looked for it by consulting the person that seized all the exhibits, that's Van Staden. My lady, we will gladly look if the court if the court instructs or indicates that the court would want us to look somewhere, my lady, we will go look. But as I'm standing here, my lady, I cannot think of somewhere to go look.
And it's not possible to go to the house anymore and look for it there.
Indeed, my lady, I think it was sold. The accused took that house over 3 days after the scene, so it would serve no purpose to go back there, my lady. So, my lady, I just don't know where to look if the court would ask me if I looked.
All right, anything else?
No, my lady, that's the only way of responding to this.
Yes, Mr.
My
Roux?
lady, I understand the difficulty, but I think it's a bit too easy. And if I may say, it's not at the house. That's the first source that we try to find.
It's not at the house.
It's not at the house.
Yes.
And the fact is, these are the cold facts. The police took possession of the house. The keys were only given 18th and 19th February, later on, when we were given access. We talk about the 14th and the 15th. The police sealed the house. The court was there. The next photo, the court's not there at the place where it was. It's gone.
When did, excuse me, when was the first time when it was realized that the extension was missing?
We saw on the photo, because we saw a number of changes on the photo that we referred to previously, and we saw on the photo there's no cord. But of course, in cross-examination, the relevance of the cord became apparent. That's when it became relevant. Not before. You see a cord that's not there, and you assume that the police had removed it as part of the exhibits. But the relevance came whether that cord could extend or not extend. And that's why we gave them the length of that cord, because that's absolutely relevant. And what I I would have thought the state should do is at least, and I know you can't order them to give them if they tell you they don't have it, but at least order them to investigate it, to say who was in control of the house, who's the person that controlled the house, that sealed the house, what does he say? Why was the court there on the 14th, and why is it not there on the 15th, whilst the police was in possession? I think at the very least, we're entitled to an explanation. And that the court can do. And if it's then a cul-de-sac, then it's a cul-de-sac with its consequences on the evidence. But if it's not, at least an affidavit by the person responsible or the person that is in control of the house to explain that. Because we have the photos to show you. One day it's there, next day it's not there. They at the house. They at detention of the house. Thank you, Madam.
Yes, Mr. Nell?
Lady.
Yes, what are you saying to the suggestion by Mr. Room? Isn't that a fair request?
For the state to investigate it now.
Yes.
May I have a moment?
Isn't that a fair request?
For the state to investigate it now.
Yes.
May I have a moment? First impression is, if it's not on the inventory, it was left in the house. Now, that might be a possibility. But if we file an affidavit from a person in charge who said, I sealed and I was...
Do we know who that person is?
Yes, my lady, we know. It was Colonel van Rensburg and Warrant Officer van Staden. The evidence was late. Colonel van Rensburg said that he was remained at the scene up until the time that they sealed it. My lady, we'll do that if it assists the court. But, my lady, I just think that we're talking about lots of things that happened.
Well, it doesn't assist to go on and on about that.
Yeah, no, it's fine.
Because
I
I think it's very important that we should know what happened
if that's
to
what the
it.
court orders.
Because what we have so far is that the house was locked.
And
there was no burglary during that time.
And we would say it was still there. It's not at a specific spot,
Yes,
but
yes. Yes, I ordered that person, whoever he is, who was in charge of the house, on the 15th, is it the 14th and the 15th of February? Is it the 14th and the 15th? Those are the dates. Are those the relevant dates?
Those are the two relevant, 14 and 15.
14th and 15th of February. Deposed an affidavit to explain exactly what happened during those days while the house was under his control. Yes.
it'll happen, ma'am.
Yes. Thank you. Thank you.
I'm indebted to thank you, my lady. Just sent for housekeeping the report by Dixon that we said we would hand it in. It's JJJ3. We gave it to the state at the time and said that you would make the hand it in. It was just an oversight. And then, my lady, the guard track, I said that I referred to at page 431, that it would be handed up, but somehow there was an oversight. It was never handed up. I've marked that, with your leave, my lady, as Exhibit TTT, the guard track of the Silverwoods estate.
Oh, thank you very much. Yes,
Then
yes,
call
yes.
the next witness, my lady. It's Ivan Lynn.
Yes. Did you not mention something else? Dixon report?
No, my lady, what happened, I made reference to a photo of the ambulance, but Mr. Nell requested me that we stand that over. He just wanted to check on it and then come back to me tomorrow.
Thank you.
My lady, similarly for this witness, we asked the order to stand in regard to media
Yes.
recording.
The image of this witness is not to be published in any form that includes filming. Thank you. Yes, the witness may be sworn in, please.
Sir, please state your full names for the record.
My name is Ivan Lin.
Do you have any objection in taking the prescribed oath?
No.
Do you consider the prescribed oath to be binding on your conscience?
Yes.
So do you swear that the evidence about to give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, so help me God.
So help me God.
Witness is sworn in, my lady.
Thank you very much. I don't think I got your name correctly.
What's the name
Can you
again?
spell it for me, please?
Ivan.
Yes.
My surname is Lin. Lin.
L-A-N.
Lin, my lady.
L-I-N.
Oh, thank you very much. Yes. Lin, that's how you pronounce it?
Yes.
Thank you very much. Mr. Lin, you may be seated if you so wish.
Thank you.
Yes,
Thank you, my
Mr.
lady.
Rowe.
Mr. Lynn, before I start with your evidence, you have compiled a report
Yes.
relevant to your evidence in this matter.
Yes.
Would you care to look at a document and identify it to be indeed your report? You have a copy with
I have
you.
a copy of my report, yes.
My lady, ask the court to accept it as Exhibit UUU.
Thank you.
Now, Mr. Lynn, going to your report, more to the back, the last annexure to your report is in fact your curriculum vitae.
That's right.
Do you confirm the correctness of that?
I confirm that.
Now, can you tell the court what are your qualifications?
My qualification is electrical engineer. I've been practicing as a acoustic engineer since 1992.
Where did you study and where did you qualify?
University of Witwatersrand,
When was that?
1992.
And after qualifying as an electrical engineer, what was your career path then?
I joined a partnership of a company involved in acoustic consultation and the design of broadcasting facilities. And I've been a partner of the company ever since. And the company there's been different form of company up to now, but still the same group of partners I've been involved with.
What is the company's name?
The present name is called Pro Acoustic Consulting Engineers.
And what was the previous name?
Pro Acoustic Consortium.
Consulting. And are you a director of Pro Acoustic?
That's correct.
And tell me, in your profession as at Pro Acoustics, what is it that you do relevant to acoustics and to sound?
We study and research the phenomenon of acoustics and how humans perceive sound and the transmission of sound and recording of sound thereof. My lady.
Now, let's go to your report, Mr. Lind, and we can deal with the questions that were posed to you. Do you have the report in front of you?
Yes, I do.
Can you start with that?
Yes. Sorry, I didn't understand.
Can you just tell the court what the question was there, right in the beginning?
The question posed, can one reliably differentiate between a male and female scream at about 80 and 177 meters away, respectively? Can one reliably discern emotion of a scream from about 80 and 177 meters away, respectively?
And then do you deal with the two questions in your report?
That's correct.
You deal also with certain definitions?
That's correct, my lady.
In order to assist the court in understanding the acoustics relevant to this?
That's correct.
Can we go to the definitions? I see the first one's an acoustic. Now, can you tell the court what are your qualifications?
My qualification is electrical engineer. I've been practicing as a acoustic engineer since 1992.
Where did you study and where did you qualify?
University of Witwatersrand,
When was that?
1992.
And after qualifying as an electrical engineer, what was your career path then?
I joined a partnership of a company involved in acoustic consultation and the design of broadcasting facilities. And I've been a partner of the company ever since. And the company there's been different form of company up to now, but still the same group of partners I've been involved with.
What is the company's name?
The present name is called Pro Acoustic Consulting Engineers.
And what was the previous name?
Pro Acoustic Consortium.
Consulting. And are you a director of Pro Acoustic?
That's correct.
And tell me, in your profession as at Pro Acoustics, what is it that you do relevant to acoustics and to sound? And decibels?
The decibel is a logarithmic unit used to express the ratio between two values of physical quantities, often power or intensity. Within the context of this document, decibel is used to describe the level of sound pressure variation.
And frequency?
The number of alternating cycles per given time unit. In this context, it is used to describe the pitch of a sound and expressed in hertz.
You can carry on.
Hertz, a unit of frequency in cycle per second. Shall I proceed to intelligibility?
Yes.
Is how you learn? Okay. Describe the degree of...
Is that intelligibility?
Intelligibility describes the degree a sound can be understood, not it is a process that involves human interpretation. Next item, mid-frequencies. Typically, the frequency range from 500 Hz to 2,000 Hz. Psychoacoustic, the science of sound perception. Next item, sound attenuation, the reduction of sound energy through a transmission medium or a barrier. Next item, sound spectrum. A sound spectrum is a way to describe a sound signal in the frequency domain. A sound signal is composed of varying mix of different frequency components, each with its own amplitude.
Then you have the next paragraph to say that the views that you're going to express later in your report must be considered with due regard to some factors.
That's correct.
Are you going to deal with those factors?
Yes.
The court should consider.
Shall I read through? Okay. Number one, hearing is a passive physiological process where audible information is received by human ears. Next item, listening is an active process where the information received by the human ears is interpreted and deciphered by the brain. Next item, 5.3. As the act of listening involves a process of referencing to information available to a specific listener, the actual perception of sound through the listening process may vary from one person to another, as each person may have different bases of information references due to factors such as individual cultural background, languages spoken, and upbringing. Next item. Perceived oral information may be intellectualized further with information available at the time and with information subsequently obtained. As such, the perception and interpretation of actual audible events are progressive processes that do not always accurately reflect the actual original event. The reliability of information perceived and interpretation is thus not always guaranteed. Next item.
What is it that you say in that paragraph?
Excuse me. The act of listening is an intellectual event, not just a passive listening. And to make sense of the sound you hear is a process by your brain and the information you process and the past information and the present information, and the presentation will come to you during a short subsequent time, because understanding of an event is a progressive process.
Does it mean in simple terms that two persons can listen to the same noise over a distance and have different views about the noise.
That is correct, my lady.
Interpretations. Because it's interpreted by the brain.
That's correct.
Paragraph 5.5.
The perception of sound by human beings may depend on a large amount of variables. First, I'm dividing into 3 categories: sound source sound spectrum, source sound intensity, etc. Second part, sound transmission, dependent on direct path, reflected path, number and types of intermediate sound barriers, ground conditions, temperature, atmospheric pressures, etc. Next point, listener, ambient noise level, in bracket, sound spectrum and time, close bracket, dependent on the state of hearing mechanism, the interpretation of sound perceived, in bracket, state of mind, and the reference information, sorry, I repeat that, state of mind and the reference information set available to the listener, close bracket. Next point. To be able to differentiate between a male and a female scream, one need to consider the following points. Point number 1. Is it correct to reliably assume that without exception, all male screams sound the same? Point number 2. Is it correct to reliably assume that without exception, all female screams sound the same? Next point. Is it correct to reliably assume that without exception, a female scream cannot sound like a male scream, or vice versa? Next point. While it is possible to differentiate human oral perception of a typical male and a typical female scream with or without visual correlations, we have found no reliable studies or evidence to support that assumptions stated in 5.6.1 to 5.6.3 above are indeed correct. And this refers to 3 points made correct previously.
What does that mean in simple terms?
That although typically one can differentiate a male and female scream, but one cannot say reliably without exception, one can always say it's a male or female scream.
5.8.
In addition to the certainty stated in 5.6 and 5.7, real-world scientific modeling and analysis are only basic way of attempting to explain the complex event of sound transmission. The modeling the modeling process excludes the possibility of 100% reproduction of original sound source and the perception of sound from a listener's perspective.
Are you saying in that is that though you can scientifically approach this,
Yes.
it is not exact because you can't replicate the human interpretation?
Apart from that, also real actual condition that when sound happened.
You can never replicate the actual conditions.
That's correct, my lady.
5.9.
From my experience and the past researches, typical human screams recorded are between 110 dBA to 120 dBA. For the purpose of this modern exercise, I shall use an average value of 110 dBA. The next point is analysis. Would you like me to read through? The purpose of this report is to attempt to answer the 2 questions posed to PACE, that's Pro Acoustic Consulting Engineers, in 2.1 and 2.2. In addition to the question regarding the reliability of human perception stated in section 5 above, a basic scientific modeling process may be used to assist in furthering the understanding of the sound transmission. The modeling process is basic due to the fact that a mathematical model can only be used to describe and simulate possible original sound transmission. It is impossible to replicate the highly complex nature of sound transmission under the original conditions. It is necessary to take the following factors into account: the location of sound source and the listeners, the environment of the sound source and the listeners, what are the possible sound transmission barriers if the listeners do not have a direct line of sight to the sound source. Other meteorological factors and the ground conditions are stated in 5.5.2 above. Next, would you like me to carry on because it's still quite okay? The possible sound attenuation between the sound source and the listeners at 80 meters is 11.1 if it's scenario number 1. If the sound source emanated from the toilet with a closed door and a window. Subpoint to this section.
You mean a closed window?
With a closed window, yes. May I continue? Thank you. Sound attenuation at the sound source site. A closed toilet window offers an estimated 25 dB sound attenuation average over the mid-frequencies.
What does that mean? Meaning if a sound was 100 dB and it goes through the window that's closed, what would it be on the other side?
We will measure 75 dBA at 1 meter away from the window. Next point, a closed toilet door with a second sound path through the open bathroom window, but attenuated by an estimated of 29 dB average over the mid-frequencies through the closed door and the small opening of the window. Second subpoint, sound transmission. The model result indicates that for a sound signal to travel through 80 meters airspace between the source of the sound and the listener position, the sound would have attenuated by between 37 and 39 dB average over mid-frequencies. Next subpoint, this would have depended on variables such as ground conditions, for example, grassland or hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next subpoint, sound attenuation at the listener's side. Subpoint, no further sound attenuation if standing on the balcony. Next subpoint, open balcony door with a limited opening into the bedroom. The expected sound attenuation between outside and inside the bedroom is in the order of 3 to 5 dB average over the mid-frequencies. Next point, sound attenuation in this scenario. Between 62 dB standing on the balcony to 69 dB listening in the bedroom, average over mid-frequencies. The main source of sound would be transmitted through the toilet window. I'm going to progress to the next scenario number 2. If the sound source emanated from the bathroom with an open window, sound attenuation at the sound source site, the sound source in the bathroom would attenuate by an estimated 9 dB average over the mid-frequencies through the open bathroom window. Next subpoint, sound transmission. The model results indicate that for a sound signal to travel 80 dB airspace between the source of the sound and the listening position, the sound would have attenuated by between 37 and 39 dB average over the mid-frequencies. Next point, this would have depended on variables such as the ground conditions, for example, grassland or hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next subpoint, sound attenuation at the listener side. Subpoint, no further sound transmission if standing on the balcony. Next subpoint, open balcony door with a limited opening into the bedroom. The expected sound attenuation between outside and inside the bedroom is in the order of 3 to 5 dB, average over the mid-frequencies. Concluding point for this scenario, total attenuation in this scenario, between 46 dB listening on the balcony to 53 dB listening in the bedroom. attenuation average over the mid frequencies. Next scenario, if the sound source emanated from the balcony. Subpoint, sound attenuation at the sound source site. Subpoint, depending where the sound source was standing, sound source at the balcony may or may not have a direct line of sight to the balcony of the house at 80 meters away. The possible sound attenuation at the source may vary between 0 to 15 dB, average over the mid frequencies. Sound transmission. The model's result indicates that for a sound signal to travel through the 80-meter airspace between the source of the sound and the listener's position, the sound would have attenuated by between 37 and 39 dB, average over the mid frequencies. This would have depended on variables such as ground conditions, for example, grassland, hard ground conditions, temperature, humidity, atmospheric pressure, wind, etc. at the time of the event. Next point, sound attenuation at the listener's side. Subpoint, no further sound attenuation if standing on the balcony. Next subpoint, open balcony door with a limited opening into the bedroom. The expected sound attenuation between outside and inside the bedroom is in the order of 3 to 5 dB, average over the mid frequencies. The concluding point for this scenario, total sound attenuation in this scenario between 37 dB listening on the balcony to 59 dB, to 59 dB listening in the bedroom. Attenuation average over the mid frequencies.
Well, anyway, moving on into the 177 meters, would this be an opportune time for the adjournment?
We take our lunch adjournment. Court will adjourn.
Listening in the bedroom. Attenuation average over the mid frequencies. Next scenario. If the sound source emanated from the balcony. Subpoint, sound attenuation at the sound source side.